I was waiting for it.
Yeah, it's a show.
Isabel, what happened on Saturday?
What?
Have you heard anything?
Oh, I thought Conor McGregor walked in right now. What the hell?
What do you
Oh, he's like, he's a here.
Oh,
He's
here?
in jail.
And at first I was like,
Well, he grew the, Conor McGregor grew them too.
yeah.
Oh,
Yeah.
well, he just got out. So-
He just got arrested, I think.
Yeah.
John,
Yeah, that guy had it coming though.
get anything done.
What the hell is he doing?
I was
Shouldn't
wondering.
get in Conor McGregor's face and try to take a picture of him.
Just told this guy. Oh, this is. We were very frustrated. It's like you were telling about not getting in the lines. You know? You're totally disconnected.
Yeah.
He's thinking one is really good.
Is that everybody?
Same time though. Teachers an approach and so we tell them and I said, you know what, those are the guys. I said, no, it's one. I think we're going to stay.
You did? Okay. Yeah.
That's why I told get out of here.
No.
I said everything I want to share with the grades of like,
Oh, yeah.
this is what I feel like it is.
No, I'm
Oh,
Do you agree? Agree?
I'm like,
he didn't start talking.
wait.
I didn't really.
Affirmative Republican.
Oh.
For like 2 hours.
You guys all ready? We're all here. The gang's all here,
Let's go.
you know? And I wasn't planning on staying until 9:15. So,
Is anybody planning on staying open?
so that being said, we're here
No, we're
as
here
long
as
as you
long as
guys
we
need
need to be,
us.
absolutely.
I know.
As long as you need us, we're here for you.
Do the week.
And even after, you guys got questions, you have our email addresses, whatever you need, you just let us know. We're here for you.
I emailed you and
We
it says
appreciate the support.
undeliverable.
Block.
You should say block. No worries.
All right, guys, we have been beating up on this force we call hearsay this whole semester, right? And you guys clearly have your analysis down, right? Yes? Look, we even got a little review, that tells you exactly. Now, the only thing missing from here, right? Crawford's not really on here, but unless it's a criminal case, right? And unless it's the prosecution trying to offer it, Crawford doesn't even apply. Okay? So why don't we start off with our rule review real quick, our analysis, then we'll go through your sample essay that you guys all worked very hard on Saturday and answer questions on that and then see where we're at. So let's take a look first at your hearsay review sheet. All right. Somebody objects to a statement because it's hearsay. Your first response is?
It's not hearsay.
It's not hearsay because?
It doesn't fit the definition of hearsay.
Not being offered for the truth.
Right? Not offer for the truth, not a
Not a
statement,
statement.
not an declarant, right? All of those things, right? And this puts this down. The words have independent legal significance, right? All of those qualify.
That part where independent legal significance, that's like if it's proving an element, right?
Or it's proving that the words were spoken,
Okay.
not that they're true.
Okay.
We gave you notice. You knew about the water in aisle 12 because somebody told you. That doesn't strictly go to an element of a negligence claim, but it helps prove that they were negligent.
It could be the forming of a contract or things like that, right? The agreement for the rent or the lease or, so the words themselves have that legal significance, and it could be that they go to an element of.
Right.
Doesn't mean they have to. Okay? Assuming you don't have a definitional response, second thing you look for, exemptions, right? And you've got 3 exemptions that deal with trial witnesses, right? The witness is there on the stand. And those 3 are?
The prior consistent statement, prior consistent, and the identification.
And the identification. And just know the rules that apply. Identification is easy. If you have provided a prior ID, it comes in now, right? Prior consistent has to be made under oath. Prior inconsistent, prior inconsistent has to be made under oath. Prior consistent has to be in response to a claim of recent fabrication, right? Doesn't have to have been under oath.
I can see where the prior inconsistent can kind of like to impeach someone, or how would you bring in a prior consistent? Like, what would you do?
Right, you're
Because somebody's said, you made that up recently. You recently fabricated it. You've got some motive to not tell the truth. Well, before that motive arose, guess what? I said exactly the same thing.
Okay, and if the witness isn't on the stand, but it's a statement of your opposing party, you got 5 of those exemptions, right? Either something they said personally, it's something they adopted, it's something they authorized, it was made by an employee within the scope of employment, or you've got a co-conspirator statement during the scope of the conspiracy. And those are your exceptions. Exemptions. Assuming you don't have an exemption, right, you've got to look at what type of exceptions do you have. Now this tells you to look at the type of statement it is. Is it a document? That should just be kind of common sense, right? If you're trying to get it in and you're trying to see which exception is going to apply, well, what are we talking about? Are we talking about spoken words? Are we talking about a document? Are we talking about, business records, right? The type of statement that we're dealing with should give you a clue as to what sorts of exceptions apply. So if they are statements that are made at some other time, meaning the circumstances under which they were made do not lend credibility and trustworthiness or reliability to it, like a spontaneous statement where you didn't have time to make it up, then you've got to look at the unavailability exceptions, right? What are they? Is a declarant unavailable? Go through the whole list of what makes them unavailable. Assuming they are, then do you have the exception to go with it? Okay. Always be aware for hearsay within hearsay. Okay. Right. You're trying to get these documents in, and they're filled with well, so-and-so told so-and-so who told me, who wrote it down, right? You gotta pay attention to that, right? You can't just pay attention, well, I want the records in, and I've got this way to get the records in, so what's contained within it doesn't matter. Okay, it does matter, because you've got to have a way to get each level in.
I have a question about that. I was getting a little bit tripped up over the weekend on that because for test taking purposes, do you want us to do a full hearsay analysis on each piece of it? Because I think what was stated in the past was if you're doing a hearsay analysis that you shouldn't just stop if you find that it's not hearsay and find all the ways that you could get it in.
Right.
So would you do that for each piece? Because that's what was just eating a lot of my time on Saturday when we did it.
You do, like, just looking at the example, you had right? You had 4 different statements,
You
and
need to analyze.
it said
46.
discuss. That's all it said. So that means we want you to discuss all aspects of it, from relevance to definition to exemptions to, and it could go quick, right? Is this relevant? Absolutely, it's relevant. Here's why it's relevant. Does it meet the definition of hearsay? Yes or no? Yes, it does, because it's being offered for truth. Well, no, it doesn't, because, right, it's not an assertion, it's a question, it's what have you, right? Those should go relatively quickly.
And then an essay, even if we find that no, it doesn't fit the definition of hearsay, we put if it does, and do the exam.
Correct,
Okay.
right, assuming it does.
Well, the one on the essay was like one of the 4 was, there were 2, because one was hearsay within hearsay,
Correct.
just one of them. So would you then break apart both of those and do a
No.
full?
Now, when you're doing hearsay within hearsay, just hit each level, right? For example, I'm trying to offer in, right, this piece of paper. And this piece of paper on its face is admissible, right, because it's a business record, right? And on this business record, it says notes from the clerk that says, customer told me her husband said X, right? Well, clearly what the employee's writing falls under the exception, because he's the employee and he has a duty to write accurately for the business. Is what the client said hearsay? Arguably, do you have an exception for it, right? Well, the client's reporting what the husband said, right? So you really do have to do an analysis. Maybe what did the husband say? Well, what he said isn't hearsay. Right? The husband said, make sure you ask him, is this covered by the warranty? Not an assertion, right? Question. So then you get to the customer. What did the customer say? Right? You got the husband's level in. What did the customer said? Well, this better be covered by warranty, because my husband said to make sure it is. Or my husband said, hey, make sure you ask him if it's covered or something like that. That's a question. Well, but hers isn't necessarily a question. It's an assertion that I expect this to be covered. Right? Do you have an exception for that? How do you get it in? Right? You just got to go through each one. And to the extent there is a need for an analysis, you do it, but I wouldn't expect you to say, if you're analyzing hearsay within hearsay, well, this furthest level of hearsay is not hearsay because it's a question. That would be sufficient to take you to the next level. Does that make sense? But in your own mind, let's say it is hearsay. Well, do you have any exemptions? No. Right? Well, do you have any exceptions? I don't know. Right? You do have to do the analysis on each level and have a way in for each level to ultimately make the whole document admissible. Right? But let's say you can't overcome that hearsay within hearsay within hearsay hurdle. Does that mean the document's not admissible?
Just that
It
section.
means that section. Right? So, hold on, I would move to redact that inadmissible portion and admit the remainder. Right? So you do have to do the whole analysis, but once you've found a way in, then go on to the next level. Does that make sense? Don't say, yeah, but assuming it was. We don't want that much on hearsay within hearsay. We want you to identify that it's hearsay within hearsay, and then and then identify whether you can overcome that. All right, and then of course 7, it talks about the interest of justice. Rule 807, like we've said, it's not a good exam choice because it's got to lay it out for you, right? There's that notice requirement, and the facts have to be given to you that, hey, and the plaintiff gave notice that they intended to use this statement. Here should be, 807, I got to write on this. So we gotta kind of tell you to write on 807 in order for you to pick it up.
In the real world, it doesn't come up. I mean, if you find yourself arguing that, it's because you just don't have any good argument.
Or you killed the essay and you've got extra
Yes,
time.
yeah.
And you're like, well, assuming notice was given, here's how I would argue 807. If you've got that extra time, well, good for you.
You should probably be doing something else.
So, questions on how you analyze it? Are you ready to jump into the essay? The rule section really is just it's a shorthand version of what the rules are, right? And a nice, easy, all in one place kind of handout. So,
Can we go over Crawford? Like,
absolutely.
Like a good rule statement for Crawford, so.
Well, what was the rule of Crawford?
Yeah, it has to do with the confrontation clause, but I'm not sure, we put this before hearsay, or do we do the analysis of hearsay first and then put Crawford at the end?
I would put it before, right? Because ultimately, you've got to get an exception in after your Crawford analysis, right? So
It's got to survive both. So whichever one seems to make more sense to you, do that first.
Okay.
And some of the analysis may be similar, right? I mean, if it's not hearsay, well, that sort of helps you with your Crawford analysis.
right? The rule of Crawford was testimonial statements made to the police accusing a defendant of wrongdoing may not be used at trial unless declarance is unavailable and the defendant had a prior opportunity to cross-examine the accuser. That's the rule of Crawford. Does it tell you what testimonial is? It doesn't. Right? Right? That's the problem with Crawford. It gave you the rule, but it didn't explain what testimonial meant. Okay? It kind of gave you some hints, right? That would the witness believe that it was going to be available for use at a later trial, things like that. But the rule says testimonial statements that accuse the defendant of wrongdoing cannot be used at trial unless it's unavailable and you had a prior opportunity to cross-examine. That's the rule of Crawford. Then you have to use all of the other cases, Davis, which gave us a primary purpose test, Michigan v. Bryant, which gave us the ongoing emergency test, right? You've got Melendez-Diaz that talked about lab work. You got to have the technician who actually did the test there to be cross-examined, right? You've got to have all of those other things come in to inform your analysis on is this testimonial or not. And the two that really make the most sense are the primary purpose test, which is right there for you. Describes events as they were occurring, as opposed to describing past events. It's a call for help for an ongoing threat rather than an explanation of events that had already taken place. The nature of questioning was to elicit statement necessary to be able to resolve the present emergency and the level of formality of the interview. Those are the things you look for. And is this from the eye of the declarant? Yes. Is it from the eye of the police? Yes. Right? Do you take them both into account? Yes. It's not from one perspective only. And then Michigan v. Bryant said if they're dealing with an ongoing threat, right, it's non-testimonial. Right? As long as the emergency remains, any statement made to the police is non-testimonial. So keep in the back of your mind, Crawford came down and put a clamp on statements made to the police. If you made a statement to the police, the only way that statement's coming in, for the most part, is if you take the witness stand and say it again in front of the defendant, and they have a chance to cross-examine you. And in all the cases that followed, loosened it up, right? To the point now where you hardly even hear a Crawford objection because most states have put it back into really just a hearsay analysis, right? You don't really deal much with Crawford, even though it's still the law that has not been overruled. It's still the case. It has been interpreted by so many state courts at all levels. There's really not much to it. And I probably haven't in 10 years had to argue whether something was testimonial or not. Because there's cases on point that tell you it is or it isn't. So when you get to, if you're doing Crawford, state the rule, state the analysis of whether it's testimonial, okay? And then analyze the rule. If it's non-testimonial, then Crawford doesn't apply. And do you have an exception? Yeah, it comes in. If it's testimonial, okay, do you have a prior opportunity to cross-examine? Yes. Let's assume it's no. Well, did they waive it? Right? How could they possibly waive it? Right? Well, they were the ones that caused the declarant to not be available, right, through their own wrongdoing. Well, then it's waived. Right? You don't get the benefit of witness intimidation and Crawford. You don't get both.
If the defendant had the opportunity to cross-examine, you should always point that out, even if you conclude it's not testimony, right? Because if you had the opportunity to cross-examine, you're good, right? It comes in, testimony or not, it comes in because the defendant had the chance to confront and cross-examine.
And then once it comes in, then you've got to do your hearsay analysis.
Right.
Right? Do you have a way to get it in?
But just because you get past the Constitution doesn't mean you get past the rules of evidence.
I have a question. It's going to seem like a stupid question. If Crawford was to, really clamp down on defendant's statements that he made to the police during interrogations, then how do...
No, it's not defendant's statements to the police. You don't have a right to confront and cross-examine yourself.
Okay.
So pick another example.
No, I guess you just answered my question.
Okay. So, and by the way, that's not a stupid question. In fact, we talked about this last week, right? Well, what if the defendant says, I object. I have a right not to testify. I'm exercising that right. You can't introduce my statements, right? And well, let's see. It was a statement to the police, clearly intended to be preserved for use at trial. The defendant has an absolute right not to testify, so he can't cross-examine himself. So Crawford keeps it out, right? No, because you don't have a right to confront and cross-examine yourself.
You have the right to confront your accusers. Those
Well, those statements are pretty damning.
Are you accusing yourself of something there? Yes.
Well,
Okay.
Not exactly, but you sure made some important additions.
Yeah. Good.
Makes sense?
You understand?
And of course, I can't emphasize this enough. We talked about it. If it only applies to evidence that the prosecution in a criminal case is offering. So if you find yourself thinking about Crawford when it's evidence offered by the defendant, you need to say, wait a second, Crawford doesn't apply because it's only the prosecution introducing evidence. And the only reason I emphasize that is every once in a while, someone gets way too into the analysis and forgets the sort of basic point, okay?
And you gotta keep in mind, we're talking about, in general, statements to the police. Okay? The police can include other people with authority. Okay?
Like somebody in a child molestation investigation, a trained investigator who's used to talking to kids about, what happened, right? That's an example. That's a kind of classic, you're not a cop, but, example.
So statements to friends and mom and, strangers, and those aren't.
How about that inmate that the police put in your, oh, yeah, never mind. If someone is working really closely with the police, it doesn't get the police off the hook. Okay, so if the police send in get your neighbor to talk to somebody who's reluctant to talk to the police, and gets evidence that way, you got a pretty good argument. That's a statement to the police. But that's getting fairly.
And what
Yeah.
would you call those guys?
Undercover.
Oh, that's well.
Informants.
Informers. They're agents. They're acting as agents for law enforcement.
Of course, often the confidential informant is getting a statement made by the defendant, and who don't you get to cross-examine yourself? So,
Sometimes they're even getting paid.
oh yes, or they're getting paid by the most valuable commodity of all. They're getting their criminal case dismissed or their sentence reduced. Now that's some currency right there.
You guys ready for Iowa?
All right,
Yes?
let's do it.
Okay. Iowa farmer, Pay Kinsella. He's a plaintiff, right? You guys are picking up on these little cues, right? Pay Kinsella, here's a voice in his cornfield telling, if you build it, he will come. He interprets this message as an instruction to build a baseball field on his farm. He then plows under much of his crops and acquiescently builds the field, upon which appears the ghost of Sockless Shoe Johnson and other players. Right? Rules of evidence apply to ghosts as well. So you know.
Ghosts are subject to the rule.
One perfect spring afternoon, Pay was sitting in the bleachers watching a baseball game with his daughter Karen and friend Terrence D. Mann. A reclusive author, Pay sought out to help him understand the meaning of the message and the purpose for his field. Pay's brother-in-law, Doubting Dave, I say that's a D name, that must be the defendant, arrives at the field. He's been pressuring Pay to sell the farm to him before Dave's company forecloses due to Pay being behind on his mortgage payments. Doubting Dave believes the ball field is a waste of valuable farming land and cannot see the players or ghosts on the field. During the ensuing argument, Karen falls off the bleachers and is injured when she chokes on a piece of hot dog. Pay sues his brother-in-law, Dave, in federal court for damages for the injuries to Karen as a result of the incident.
Assume that federal courts have jurisdiction over this claim.
And you are saying, yes, no Crawford, civil, no police. And you will soon be saying, yes, no Prop 8, no. At trial in his case in chief, Pay testified that he was watching the ball game, minding his own business when Dave arrived. He further testified that Karen calmly told him she saw her uncle coming. He looked mad and was walking recklessly across the field and through the game, almost being hit by a pitch. Pay also testified that about 30 seconds later, he saw Dave appear in front of him. Dave was mad and yelling about selling the farm. Pay testified further that Karen asked her uncle to sit down and enjoy the game. And Dave responded by grabbing Karen by the arms and shaking her, causing her to fall backwards off the bleachers to the ground. Pay then called Terrence, who testified that after the incident, he spoke with Dave about what happened. As soon as Dave walked away, he carefully wrote down notes of what Dave said to him. Terrence testified that he had no recollection of the conversation. Pace showed him a copy of his notes and he identified them as the ones he wrote down immediately after the accident. The copy of the notes was admitted into evidence. The copy of the notes stated that Dave told Terrence that he was at fault because he was angry and shouldn't have grabbed Karen. The notes also stated that he offered to pay any medical expenses for Karen, and Pay rested his case. In his case in chief, Dave was the only witness. He testified that Pay was sitting in the bleachers with his niece staring at an empty field. He shook Karen, who seemed to be in a daze, and she pulled away from him, falling off the bleachers. Dave testified further that there was a doctor on hand, Sunlight Graham, who treated Karen by slapping her on the back, causing her to cough up a piece of hot dog. Dave testified that Dr. Graham said, "The child will be fine. She'll be turning handsprings by morning." He also testified that Dr. Graham was last seen disappearing into the corn stalks and has never been heard from again. As Dr. Graham walked away, Dave saw a number of baseball players on the field, and he overheard Sockless Joe tell Dr. Graham, "Hey, rookie, you were good." Dave immediately turned to Pay and told him not to sell the farm. Dave rested his case. Now, assuming all appropriate objections and motions were timely made, should the court have admitted Karen's statements? Okay. So hopefully the first thing you're doing is you are identifying what are Karen's statements. Okay. And if you go there, 4th paragraph down, right? Pace testified, and he testified that Karen calmly told him she saw her uncle coming. He looked mad and was walking recklessly across the field and through the game, almost being hit by a pitch. Okay? That's what Karen told him, calmly. Second one, right? Dave appeared, Dave was yelling. Dave testified further that Karen asked her uncle to sit down and enjoy the game. Right, so you've got 2 statements by Karen. The first one, defendant's coming, he looks mad, he's walking recklessly across the field and through the game and almost got hit by a pitch. Is it relevant?
Sure, why not?
Sure. Right? Talks about his demeanor. He's charged with causing injuries to Karen. Whether he was angry at the time he did it, and to make that fact more or less probable. Relevant. Right? Is it hearsay?
Is Karen a declarant? Yep.
Out of court?
Yes.
Offered for the truth?
Yep.
Okay. You got any exemptions? Right, Karen's not testifying, and she's not a party opponent, so you've got no exemptions. Do you have any exceptions? Right,
What exceptions?
remember,
Present sense impression.
right? This sure looks like a present sense impression, right? She is
She's
describing
describing
it
what she's seeing,
as she's seeing
as
it,
she's watching.
right? Sure. Is it an excited utterance?
No,
No.
because she's not upset.
Is it a statement of Karen's then existing mental, emotional, and physical state? Statement with regards to medical treatment?
Not this statement.
Right? Is it a document? No. is Karen unavailable? We don't know, right? We don't know. For presence and impression, her availability doesn't matter, right? So you don't know if Karen's unavailable. Assuming she was unavailable, do any of your 804 exceptions apply? Right, the statement against her interest, right, a statement of family, right? They really don't, right? So 403, right? It's more probative and prejudicial. Should court exclude it? Should court let it in?
We'll probably write it in.
Yeah, just show that you did the balancing.
Yeah.
Okay, so, and you're done. Then
With the
Karen,
first statement.
with the first statement.
Statement number
Karen's second statement is, Uncle, why don't you sit down and enjoy the game?
is that it? Okay, Karen, we decided was a declarant. Is she a declarant here? Is she making a declaration? She's sort of inviting her uncle to sit down, which is not a true or false statement, right? It's, why don't you sit down?
And it says asked, right? Karen asked her uncle to sit down and enjoy the game.
So probably not offered for the truth. How could it be? So does the hearsay rule even apply?
Yeah, it's a question, right? It completes the story, right? It's not something that you even need to worry about whether you have an exception or anything for it to come in.
Wait, so we don't have to continue with that then?
How would you?
It's a
Yeah.
question.
Yeah.
Right.
Notice how I answered that with a question.
No, but the problem is, like, let's take the first one, right, where she's describing her uncle being mad and coming over, and you say, well, that's not offered for the truth. Okay, wink, wink. You want it for the truth, but you're offering it for some other reason. Okay, and it's not certain the court's gonna rule your way. You better do some further analysis. Okay, and keep in mind, this is in the context of Karen. You've already done a full hearsay analysis with the first statement. So having a more abbreviated one for the second, it is a little more understandable, right? And maybe it's not hearsay, it's not an assertion, it's a question. And then you go and you do all the other ones, and you come back and you have 10 minutes left. You're like, well, assuming it was, right? And you want to fill it out and impress us with, the fact that you can't find any exemptions or exceptions that apply either.
Gilding the will.
You can do that too. Okay. A copy of Karen's notes.
So what do we know about those notes?
We wrote it down.
Immediately after, right? He acknowledged that it was made, the notes were made when he still remembered it. Okay. So, is he a declarant?
Yes.
Yep. Is it being offered for the truth? Yeah. Any exclusions? Can't really think of any. Okay.
Well, who made the statement?
Dave.
The defendant, right?
Well, that's one level of hearsay, right?
Right.
Yeah, this is where I got confused. I was
Yeah.
like, well, does the exclusion apply? Well, it depends on what thing hearsay you're looking at.
Okay, so if Terrence's statement includes a statement of somebody else, you have to analyze both levels, right? So one of them's real easy. It's a statement of Dave. Dave? Yeah.
Dave.
The defendant. So that's a statement of a party opponent. So that's excluded from hearsay. So then you're back to talking about Terrence's statement, right?
But make sure you identify that,
Yeah.
right? Make sure that when we're talking about.
There
the
are
notes,
multiple, yeah, you should be saying there are multiple levels of hearsay.
Yeah, put a heading, multiple hearsay, and talk about it.
Because clearly Dave's statement is being offered for the truth, right? So-
And with each of the, hearsay within hearsay, do you want us to do the 401 and 403 for each of those statements?
Well, it's, in theory, you could have a statement that's relevant, but the included hearsay isn't relevant, but I can't imagine, I don't remember ever seeing that.
Okay.
So I would just treat the whole statement as, is it relevant or not? Yeah, of course it's relevant. But the important thing is you gotta make sure that we know that you know that there are multiple levels of hearsay and that you analyze the admission of both levels, or having, is it hearsay? Is there an exclusion or exception? So for Dave's statement, yep, it's being offered for the truth, but we don't call it hearsay because Dave made it, right? So that's one level. Might there be a 403? I guess, but it's hard to think how that would be unduly prejudicial or take too much time. Because it's kind of really helpful, so it's kind of really relevant. All right, so what about Terrence's overall statement? Terrence is clearly a declarant. It's being offered for the truth. There doesn't seem to be an exclusion that covers what Terrence is saying, right? So is there an exception to the hearsay rule that applies?
Against penal interest.
How is it against his penal, how is it against Terrence's penal interest?
Well, it's already in criminal law. Or is it in
No, that would be civil
Because he's
too,
saying
but
he
how,
was
how,
at fault.
how is it?
Well, that's.
No, that's Dave. We already decided that Dave's
Oh, okay.
isn't hearsay because it's excluded. I mean, yeah. But Terrence, this isn't against Terrence's penal interest, right? But it sure looks like it was Terrence's past recollection that was recorded, right? It was fresh in his mind. He wrote it down. Another part of that would be somebody else wrote it down under his direction. But either way, it got written down. He wrote it down. And he doesn't have, even with looking at it, a present recollection of what he heard, right? Or what he observed. So it probably fits within that, except that doesn't get the document in evidence, right? It gets the document read into evidence. So the judge apparently screwed up here by admitting it. So assuming that there was a timely objection or motion to strike or both, the court properly admitted the content of the statement, but improperly admitted the document itself. So the document should be stricken and just read the content into the in front of the jury. And just by way of record, and why do we have that bizarre rule for past recollection recorded? Because if Terrence is on the witness stand testifying and he did remember, he wouldn't introduce a copy of what he said. He'd get to say it to the jury. So by reading what he wrote down when he did remember it, we're sort of substituting that for him saying it from the witness stand and not giving it the additional weight, authority, gravitas, whatever you want to call it, by putting a piece of paper in evidence that the jury will have with them in the jury room.
I'm sorry, just let me clarify. He said they can read this.
They can read the document into evidence,
Okay.
but the document itself isn't admitted and sent back to the jury room with all the other exhibits that were received into evidence.
So it can be read into evidence as in like when he's on the stand testifying, it can be read to the jury?
Or after he's on the stand, yeah.
Yeah, okay.
And Your Honor, we'd like to read it. Yes, thank you. Read it.
The witness reads it.
No, somebody reads it,
Something, doesn't matter who reads it.
does not matter.
But isn't there a specific party that must admit that into evidence for it to be
Pardon
read? Isn't there supposed to be a specific party, the opposing party? That had
No.
admits?
This is admissible because Terrence says, I wrote it down. What I wrote down, I recalled it, right? When I wrote it down, it was made by me or under my direction, and I don't have any present recollection.
Just, I think I understood, what you're saying is, Pay
Uh-huh.
can admit the contents by having it read.
Right.
Dave can introduce the
Can
document.
introduce the document if he wants to.
Right,
The opposing party
Yeah.
can introduce it.
Okay.
Right, is that
Yeah,
what
that's
you're?
what I was wondering.
yeah,
Yeah.
The part portion.
Right.
Well, that's,
but
you
it's
gotta
not
keep,
being offered by
yeah,
Dave.
so when you guys are analyzing this, that's all stuff you're gonna wanna say, but you wanna keep in mind where this is at, right? Pay's case, Pay's witness, on the next page, it says Pay then rested, right? So you should be talking about, this shouldn't have been admitted into evidence, right? Because the rule says all that Pay can do is read it. Dave could have admitted it into evidence if he wanted to. And it doesn't tell
But
you.
there's no indication he wanted.
Right, so you want to tell us that you know that rule. What else jumped out at you in Terrence's notes? Something should have been jumping all over you.
They offered to pay medical expenses.
Oh, yeah.
And does that come in?
No.
Yeah, but it's in his notes.
It
Right,
was
it's
said
in
by
his
a party
notes.
opponent.
That's what Dave said. Right?
You would exclude that portion.
You'd have to exclude that portion. Right?
And notice you exclude that even though it's exempted from, or it's not covered by the hearsay rule because it was made by a party opponent. So if you stop your analysis at, hey, does the hearsay rule apply? And say, well, no, it's not hearsay, right? It was made by a party opponent. Well, wait a minute. Even though it's made by a party opponent, even though the hearsay rule doesn't apply, we still don't admit it, right?
Questions on Terrence's notes? There really was a lot in there that we would have expected to see on the paper, right? Hearsay within hearsay, past recollection recorded, whether it should have been admitted or not, state whether it needs to be redacted with regards to the medical treatment statement.
Do you have a model answer for this one?
I'm sure there was at some point. I don't have to do it.
That's why we're talking about it. That's why you're taking notes.
Yeah.
When it's fresh in your recollection.
Right, and then of course you still
Right,
come
to
under,
your side.
you still come under it with a 403.
Right.
I think with hearsay within hearsay, it's a little difficult because what we've kind of been taught is to treat them as two separate analyses, right? And it's just hard to keep them broken apart, if that makes sense. Because the whole analysis, it seems like, unless you stop at the exclusion for, Dave's statement? Not Dave's statement,
Yeah, basically.
Dave's statement, the whole rest of your analysis would be interwoven.
Just do it separate, right? You have this statement by Dave. Is it covered by the hearsay rule? No, because it's a statement by Dave. Except that part of it doesn't come in anyway because we have this rule against admitting offers to pay medical expenses. Then say, okay, now is Terrence's statement admissible, right? Because you can't get Dave's statement in unless you get Terrence's statement in too.
Right.
So I break it into pieces like that.
And make sure, whenever you're doing hearsay within hearsay, identify who your declarants are and what their statement is.
Right.
Right? And then the analysis flows easily. Okay, you're just doing the exact same hearsay analysis as you did on every other statement, if it was a standalone statement. Okay? So I just want to make sure you guys understand that how you ferreted this out and how you set your headings, your hearsay should still be the same, right? But when you got to the, the offer for the truth, sure, right? Is it, are there exclusions? Maybe not, right? At some point, you need to throw in there hearsay within hearsay, offers to pay medical expenses, and the like. And when you get into hearsay within hearsay, make sure you do the separate analysis for each level. Okay. Are we good on Terrence's notes? You see how it kind of held your hand, though, right? The facts have to kind of walk you down. And when you were reading those facts, you probably like, here we go, past recollection recorded, right?
Offered by medical expense.
When you're talking about Karen and it says Karen calmly told, it's like, okay, why are you telling me calm? You're trying to negate, right, something. Or Karen excitedly told me, right?
Yeah.
The facts have to give you the information.
Karen shouted, "Oh my God, my uncle almost got hit by that pitched ball," right? I mean, we don't have that obviously, but if you did, that might suggest the excited utterance in addition to the present sense impression or spontaneous statements, right?
So now we're on to Dr. Graham, right? And his statement was,
The child will be fine, she'll be turning handsprings by morning.
relevant?
Sure.
Yeah, it goes to, how
Was
the
she
image is-
injured?
Yeah, right.
Right? He's being sued for injuries. Like, you got a doctor, allegedly, right? You got a doctor saying, she's fine. She'll be turning handsprings in the morning. Is it hearsay? Is it being offered for the truth?
Yeah.
Right? If it's not, then
What is it being?
what is it being offered for? Right? Dave wants it in to show Karen was fine. Right after this happened, she was fine. Doctor said so. Okay? So, party opponent? No. Testifying witness? No. So you don't got exclusions and exemptions. You got any exceptions? Right? Dave's not there. I'm not Dave. Dr. Graham's not there. Right? So how about any of the exceptions that don't require him to be there?
Would it be a medical diagnosis saying she's fine?
Well, remember, those are
Oh,
statements made to the doctor.
to the doctor.
Did our plaintiff have anything to do with Dr. Graham disappearing?
This is perception. Or this is Dr. Graham, not real.
I guess we don't know, so would you mention that, because he's last seen disappear, or he disappears? Right,
Well, I just want to make sure we address the ones where he's not here. Okay, before he's unavailable.
Right.
Okay? Any of those apply? Any that you think apply? Not an excited utterance, not a statement for medical diagnosis.
Would it be the existing mental?
Well, that would be his existing mental, right? Could it be a present sense impression? Maybe, but what is he? Right, he's sensing that she's fine, right? Is that really what a present sense impression is talking about? It's more.
Contrast it with her pulse is 72. Her respiration is normal. That could be a present sense impression, right? Because he's just observing that and repeating what he's observing. The diagnosis or the conclusion that she's fine and that she'll be doing handsprings really is take your present sense from examining her and reaching a conclusion, a medical opinion, a diagnosis, call it whatever you want. So it's sort of taking another step beyond what you're observing while you're observing it. Does that make sense?
Yeah, that makes sense.
We just point that out because we get that a lot. Well, that's a present sense impression, right? That's doctors, that's what he's seeing right there. And then, oh, it's Dr. Graham's then existing mental state, right? He thinks she's fine. That's why but it's gotta be
His mental state.
his mental state, not what he thinks she is,
Yeah.
right? His then existing mental state is, I'm upset, I'm angry, I'm jealous, I'm
cool.
cool, right? I'm a good baseball player,
Yeah,
right?
I got one at bat.
So assuming you don't have any of those, and I just want to bring those two up because we've seen those as answers, right? Be careful. Be careful when you're analyzing it. So now assume he's unavailable. How is he unavailable? Why is he unavailable?
Probably a ghost.
Right, well, if
Could be a ghost.
he is, well, we tell you about Sheila Show Jackson, we don't tell you about Dr. Graham, right? We don't tell you he's a ghost. So let's assume, let's just walk through the legitimate basis for unavailability, right? He asserts a privilege. He
No.
asserts he doesn't remember.
No.
He says he's dead or he's sick, right? We don't know those, right? Dave says, I haven't been able to secure his attendance and here's all the efforts I've made, right? Do you have an exception that applies even if you get him unavailable? Do you have an exception that applies? An 804
No.
exception. See? But what if Pay's responsible for him not appearing?
What'd you say?
What if the plaintiff is responsible for him not appearing?
Forfeiture by wrongdoing, right? If Pay is responsible for the unavailability of Dr. Graham, how could Pay be responsible for that?
Who built this
He
death trap?
built this thing, yeah.
Right.
He set it up so that Dr. Graham could go off to the other dimension or something like that. Wouldn't have happened without him. Right? I'm not saying that's the best argument in the world, but man, Dave really wants to get this in.
I think I wrote that. I wrote that.
You're getting too. I want to take you back to Star Wars. Use the rules, right? Don't get caught up with, oh, we're in outer space and, this isn't even a human and it doesn't matter. The rules are the rules, okay? So assuming Graham is human and not a ghost, do you have a way to get a statement in?
If you caused it, is that where?
Yeah.
If Pay caused
Yeah.
it.
And do you have enough evidence to suggest that Pay caused it?
You said you said.
You've got a crazy man who's hearing voices that plows under this valuable farmland, right? And all of a sudden, people appear and disappear.
And by the way, they invited him. So the people that he brings to the field invite Dr. Graham to go off with them and disappear. Okay, it's not completely crazy.
Can you use movies that I don't know?
Do you not know this movie?
I do know this movie.
So what
and
difference,
I
so
keep
seriously,
playing it in my head.
so seriously, what difference is it? It's pretty close to what actually happened.
Right.
Did you write this exam?
We did.
You can give Professor Nolan full credit.
The rules are still they're still the same rules, right? Don't get caught up with, well, I don't know if this applies to, I think he's a ghost. It doesn't tell you the rules don't apply if they're a ghost. It's,
And by the way,
No, I just think it's just a kind of strange fact pattern.
it's a cool movie though.
Yeah.
well,
And by the way, I think in the movie, was Dr. Graham a ghost?
I don't think it was.
I don't think he was either. Although he did sort of disappear.
He did disappear.
So we're saying if Pay was responsible for his Dr. Graham's unavailability,
Then,
then
You may have a way to get it in.
yep,
If he wasn't, no, doesn't look like there's any other way to get it in,
sorry, Dave.
So this is two-part
right?
answer.
Yeah.
Okay.
Yeah. So if you're talking about Dr. Graham's statement, you should reach the conclusion that really the only way it's coming in is if Pay had something to do with his disappearance,
After you go through,
right? Because that's the only, because if you find him unavailable for any other reason, you don't have an exception to attach it to. Right?
Why again is it not present sense impression? Why? what's the-
because it's more than just a present sense impression. It'd be a present sense impression if while he's taking her pulse, he says, her pulse is 72. That's what he's sensing. It's not an opinion. It's not something based on what he's sensing. It's just what he's sensing. Or her respiration is 20, right? It's not something based on that. It's just something that he's observing and he's saying it while he's observing it. To get to the opinion that she's fine, you take in that information and you process it and do something with it. Right? So you're doing more than just observing, you're analyzing.
Okay.
The present sense impression is just, as I'm watching it, I'm saying it.
But isn't it immediately after too? That's where I'm getting tripped up on.
Well, this is immediately after.
Yeah,
He just examined her.
yeah. So
So that's not why it's not admissible as a present sense impression. Right? If it really was, I'm observing her heart rate and respiration, then yeah, it probably is a present sense impression. Because it's what he's observing and he's saying it right as he observes it or immediately afterwards. But if he does something to it, if he analyzes it, if he puts 2 and 2 together and comes up with a diagnosis or an evaluation, then it's more than just what he's observing it while or immediately after he observed it. Does that make sense?
yeah.
Okay.
So the diagnosis is based on his own thoughts.
It's
Not
more
just
than
a
just what he's
reaction.
observing,
Okay.
right?
Okay.
It's so. I mean, if you want to sort of break it into pieces, it's present sense impression plus analysis,
Okay.
right? It's what the thermometer said, plus I'm running it through my brain saying, I've considered this, I've considered this, I've considered this, she's okay.
And you'd want to cross-examine Dr. Graham, right?
Why do you think she's okay?
What are you basing that opinion on? Right, that she's fine. Right, the whole point of a present sense impression is it's trustworthy and reliable on its face that there's no reason to cross-examine it. Right?
And you didn't have a chance to make it up because you're spitting it out right as you sense it.
And the analysis is the same whether he's a ghost or not. Right? And then lastly, but certainly not least, Sockless Joe. He says to Dr. Graham, "Hey, rookie, you were good. objection, hearsay, and you say,
Well, relevance,
is it relevant?
what are the issues in the case? Was Karen injured? How badly was she injured? Was Dave responsible? Does this relate to any of that?
No.
Wow, we actually got a relevance objection. That works.
But let's assume it's relevant.
Yeah, no, but I assume it's relevant for something, right?
You know, let's
Because remember, relevance only has to be a little relevant.
for argument's sake, look, and this is what you gotta be careful of on the exam. Right? When you are analyzing these, analyze them as the question asks you to. Okay? So for purposes of Sockless Joe's statement, does our analysis change whether or not Dr. Graham's statement comes in? For test-taking purposes, no. In real life, of course it does, right? If Dr. Graham's statement doesn't come in, then there's no relevance to Shockless Joe's statement. But if Dr. Graham's statement does come in, there's some relevance to this. I would argue yes. Now, relevance doesn't make it admissible. What's he doing?
He's congratulating him for his, whatever he did.
For whatever he did. You saved that kid's life. You're a good doctor, right? You're a trustworthy witness. Your opinion matters, right? What does he mean by it? We don't know. But he says you're good. He's just told Dr. Graham you're good. Does Dave want it in? Of course he does.
Sure, why not?
Right? Is there a whole bunch of reasons why it shouldn't come in? All the things we just talked about, right? Can you vouch for your own witnesses? No, right? Is this character evidence? Kind of. You're saying he's good. Remember, this is your midterms are cumulative, so expect little Easter eggs. You know, like oh, he offered to pay medical expenses, right? Some people. This was a real question we gave. Some people went down Dr. Graham as an expert. Right? Was he qualified as an expert? We don't know. It doesn't give you anything. So, you know, so you keep that in mind. Don't go into this with blinders on this.
It's just hearsay.
This is just hearsay. I don't see anything else. Right? We expect you to see everything that we've covered up till this point.
Which is one reason why we might want to start with irrelevance.
We're giving you a hint that hearsay is probably going to be on this test, but don't think it's the only thing that's going to be on there. Okay? And if it is, lucky you. Right? If it's not, we told you. So, you know, do you got a hearsay objection? Sure. Right? Do you got ways that things that you could talk about with it? Yeah. And he's a ghost, so it doesn't need to be analyzed, shouldn't be one of your questions. One of your headers. Right? The rules of evidence don't apply to ghosts. Right? That's why we don't use movies anymore, because you guys spoiled all the fun.
So do you get to introduce that Shoeless Joe is, you know, found responsible for taking bribes?
Oh, sure seems like proper impeachment. Well, I don't know. Is that a moral turpitude?
Yeah, moral turpitude.
You know, it's.
They didn't like him in the movie.
Yeah, they really didn't like Ty Cobb. We digress.
Yeah, we digress. So there were things to talk about with Soccer Joe, and we didn't get to see her. We just found out tonight. Oh, did we email you their responses? They
No.
did. They did. So we haven't seen your responses.
But when you go back and look at your responses, think about what you've done.
Don't look.
That bad, huh?
I just got caught in the weeds. Yeah. You know, it just, I got halfway done with the question. That was it. I got to the first two and then there was already time. So.
So you didn't have an extra 15 minutes to start talking about 807 and.
And by the way, one just really minor thing that only if you had absolutely tons of time might you think about it. This lawsuit is being brought by Pay, right? Maybe partly because who can't bring the lawsuit, who's got to have a guardian ad litem bring it for her? Karen, because she's a minor. So maybe you've got a question about Karen being a party opponent if there was some statement of Karen's being offered by Dave or whatever. Okay, so if you got to, well, Karen's not a party, you might think about, well, she's sort of a party because the lawsuit is being brought on her behalf. And I don't mention that because, you know, it's pretty clearly it's not being offered by Dave and, you know, whatever. But if you had like tons of time and you really wanted to mention that little nuance that whether Karen's a party or not, arguably she is. If they were offering her state, that might not.
So now that you guys are
Thoroughly
thoroughly confused by this question,
Yeah.
right? This question is supposed to review for you how you would attack just such a question. And
Well, what happens if you, for instance, I read the "Hey, rookie, you were good" statement completely different. I read it as tell Dr. Graham that when he said "Hey, rookie," that he was actually playing ball. That he was a ghost.
that's because you saw the movie and you're referring to.
You know, so I thought it had nothing to do with Dr. Graham's medical treatment. That hey, you were good. You were a good ball player.
Yeah,
Maybe that's what it
why
means.
wasn't
We don't know.
Yeah, but you're Dave's attorney and you want it in. How do you get it in? Right?
That is not how you get it.
That's not how you get it in, right? You're Dave's attorney because you want it in, and you know, and the reason you want it. Just step back. What is Dave trying to do? Dave essentially concedes that he did this, right? In his case in chief, he's the only witness. He says he was there. She said days. He shook her.
Right.
And she pulled away.
Yeah. So he's sort of saying, hey, she did it to herself,
right?
but he was still involved, and he's the adult.
But look, a doctor on scene said she's fine. Right after this happened, she's fine. And how can you take the word of that doctor?
He's good.
One of his colleagues told him, hey, you're good. Right? All things you're not allowed to do.
Yeah.
But you see why he might want to do it. Right? We would all love to be able to do that. And a trial is just put your witnesses up there and then vouch for all of them, tell you how awesome they are. But you don't get to do that. Okay? So, and be careful about just putting your own spin on what you think it means. It could be helpful, right? If you think, here's how I can use this, that could be good. But if you're like, I don't see any way to use this, you're not moving any analysis forward, right?
Yeah, so with that, it's like, well, yeah, maybe he's talking about his baseball skills, but if that's what he's talking about, well, that's, you know, pretty clearly not relevant. But he's talking about his doctor skills or his honesty, yeah, well, maybe it's relevant, but it's inadmissible for other reasons.
And we only know he's I'm just double checking. And we only know he's a baseball player because we saw the movie.
Yeah.
But the facts don't tell you he's a baseball player. Right? It says there was a doctor on hand, Sunlight Graham, who treated Karen. Right.
So if we run into a declarant who's not a human being, who's a ghost or a stormtrooper, or something, we should.
Stormtroopers are humans too.
Yeah, I'm not sure the ghosts are
No, so-
declarants, but
But
anyway,
if we run into some kind of fictional character, should we say if, you know,
if this were
if this
a
were
declarant,
a declarant, right?
Yeah.
Right,
Yeah,
okay.
I mean, the whole point in my mind, and you see, if you look at other tests, and sometimes I'll give them to you guys on Saturdays, I don't know if they have, past tests that we've used, they're boring now. They're boring. We don't use movies. Why? Because people complain. Right? We thought, I say we, when I put this together, I thought,
pretty cool.
yeah, this would be a neat little thing, right? You know, these are all movies that I liked, you know, Star Wars and Field of Dreams and Tombstone, and I thought these were great movies, and then it got in the way. So now you got Daisy and Petunia in the flower contest, and
wait, that's kind of like Downton Abbey. By the way, real life, remember what Moonlight Graham only got into one game, didn't get the at bat, never played in the majors ever again. But that wasn't the end of his career. He was a minor leaguer for 3 more years. So sort of, yeah, it was like with Moonlight Graham, yeah.
so
it's
this
like-
true story,
Yeah,
you know, doesn't tell you all the facts.
and I don't think Moonlight Graham became a doctor either, but what the hell?
Yeah, so we don't use ghosts and
Yeah.
you know, and whatnot. Took all the fun out of it, you know.
And we don't know if Moonlight Graham's wife liked blue hats.
So
Might have.
we're here, guys. What do you got? What do you need help with? What do you not understand?
I just have one more thing I would just say, we can use some analysis. So going back to number 2, copy appearances notes. You want to start by analyzing the contents of it first, right? If you can separate.
Either way,
You can do either way.
either way,
Okay.
whatever makes sense to you.
What and what I'm telling you this because we've seen it too many times. Okay. Identify before you start analyzing who's my declarant and what did they declare. Okay, right? You start going through this whole analysis and you're like, well, Terrence said that Dave admitted to him. You know, so Terrence is my declarant, and Terrence said it was my fault. No, he didn't say it was my fault. He said Dave said it was his fault. So Dave's the declarant of that. It's easy to get confused. So if you just start off right at the beginning, who's my declarant? What did they say? Oh, I'm going to pay for all your medical expenses. I've done no analysis, but I've already identified in my mind, I've got to talk about that. I got to talk about that rule. My offer to pay medical expenses are not allowed to demonstrate liability and blah, 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 blah. So if you did that, you would have identified Terrence, notes. Within those notes, Dave, and his statements.
And it really doesn't matter which way you do it. You might say, I'm going to do Terrence's statements first, because that's relatively clean. He's a declarant. It's got this one exception, right? And then, but there's a second level of hearsay, right? There's Dave. So then I'm going to talk about Dave because I got the party opponent, so it's not really hearsay. So that level isn't, but I've also got this offer to pay medical expenses. So maybe you do, but you could do it the other way around and say, I'm going to take the first level of hearsay, which is Dave's statement, then I'm going to do the second level of hearsay, which is Terrence's statement. Whatever makes sense to you. But as Professor Nolan says, the important part is to recognize there are multiple levels of hearsay, because if you don't do that, you aren't breaking them apart and it gets all muddled.
the wrong answer is, yeah, this is a past recollection recorded and it should come in. Right, that's a wrong answer, right? Because you didn't talk about the hearsay within hearsay, you didn't talk about operating medical expenses, you did not talk about that it can only be read in by pay, right? That only Dave could have offered it in, right? You haven't talked about the issues relating to this piece of evidence. Yeah, maybe you came to a conclusion that's accurate, that his notes should have come in as a past recollection
Or it
recorded,
misses a whole
but you
lot.
missed a whole lot.
And it's more important that we know that you see the issue than that you get it the way we would do it. And by the way, that's a great lesson for the bar. The bar examiners don't seem to care so much about you getting the issues right as they care about you identifying the issues and talking about
I have a question. It's just a thing. As one of the exception is unavailable as a witness, it's if the court will rule if a privilege applies. So being a minor, like Karen was a minor, with the court,
it. That's not a privilege.
what is a privilege then?
I have a right not to testify against myself. I have a right not to prevent my attorney from testifying to what I told him or her, or my doctor, or whatever.
Okay.
Good question. Describing being offered for the truth of the matter asserted, I've just always struggled with that. I don't know what it is.
Think about, do you want the fact finder to believe that the content of the statement was true or false?
But couldn't you argue it either way? Like if you look at like Karen's first statement, Karen calmly told him she saw her Uncle Dave coming. He looked mad. He was walking recklessly across the field. Is that being offered to show that she saw him coming, he looked mad, and he was walking recklessly, or is Pay?
Wouldn't Pay want the fact finder to say Dave was upset, he was acting recklessly, he wasn't calm and collected?
Yeah, to
Because,
show.
and the reason that you would want that is, it tends to support the conclusion that he acted rashly when he touched Karen. So you want the jury to believe that all that stuff is true, because it helps you win.
But that's the reason you'd be offering it though, is to show that Dave is responsible. You know,
Right.
going towards that he's responsible. The truth of the matter asserted would be to show that he's actually walking across the field.
And he's upset.
Yeah.
He's not paying attention to anything. He's angry. That tends to help you, if you're Pay, win. So you want the jury or the judge, whoever's the fact finder, to believe it's true. An example of we don't care whether it's true or something that couldn't be true or false would be Karen's statement, "Uncle, sit down." Now, maybe you could draw some inference from that he was upset or something. But that's a lot closer to the, I don't care whether it's true or not.
Yeah, no, I the second statement I completely understand. It's just that first statement because what is she really? I understand why you would be offering it, but arguably you could say that maybe they're offering it to show that he walked across the field. You don't know why they're offering it. The facts don't tell us that, so that's why I get so confused about it.
Well, think about, why would you offer it? You'd offer it because it tends to show that he was upset and acting rashly, and that tends to show that when he interacted with Karen, only moments after he walked across the field angrily, that he did something stupid or negligent. And he shook her and caused her to fall off the stance. So you want the fact finder to believe all that stuff is true, that he was angry, that he wasn't paying attention, almost got hit by a pitch ball because he wasn't paying attention, because he was upset. Okay. Right? So yeah, I mean, am I reading the mind of the proponent of the evidence? Well, yeah, that's why you offer this.
And generally speaking, when you're saying you're not offering it for the truth, it's because you can't get it in another way, right? You don't have an exception, so you gotta find a way. I'm not offering that for the truth, I'm offering it, for this other reason, and now it can
Yeah,
come in.
wink, wink, yeah. I'm
Now
not
it
over for
comes
the
in.
truth.
Right, and don't go down in the weeds on it, just, do you have a legitimate reason, right? Robbery case, the guy says, give me all your money or I'm gonna kill you. Right, and you're offering that. Are you offering for the truth that if you don't give me all your money, he's gonna actually kill you? Or are you just offering it for the fact that
Those words were said.
spoken, right? Do you get it? It's not being offered for the truth. It's being offered to show things were said that would lead somebody to be in fear, right?
But isn't that the truth of the matter asserted? I thought that's what the truth of the matter.
But that's not why you're offering it.
The truth is those words were spoken, right? You're not saying,
So in this
and we know that he intended to kill him.
But in this case, right, with the first statement here, then the truth would be that he walked across the field.
Yes, that's right.
So that's what you're saying, the truth of the matter asserted
Yes.
is that he's walking across the field.
And how he's walking across, what his demeanor is like as he's walking across the field. Yes, that is the matter asserted.
Okay. I don't know why this is tripping me up so bad, but it just is, and I know when I get in the weeds.
Yes,
I'm trying not to.
the way I kind of look at it, and I ask lawyers this a number of times when I get a hearsay objection, is do you want the fact finder to believe that the content of that statement is true, or does it matter? Well, if it's your money or your life, right? True or not, I don't care. I just want the jury to believe those words were spoken, right? Because that's what I got to prove, force or fear.
And sometimes you want it both.
Yeah.
Right? Sometimes you want the jury to believe it's true, but you don't tell the court that, right?
You know.
Right? Because you have, right, the robbery, right? This guy comes in and he says, I don't know, I'm Southside Crip. You better give me my money or I'm going to kill you. Do I want that in for the truth of the matter asserted? Of course not, Your Honor. I wanted to show the fear. The words were said to instill fear in the clerk. Right? These are words of legal significance in that they demonstrate this is a robbery.
the guy's a crip too.
Right? But do I want the jury to believe it's a crip? Sure, absolutely. But I don't tell the court, well, yeah, Your Honor, I want it for the truth. No, I want the fact that the words were said. It doesn't matter if he's a crip or not.
Yeah, the problem, of course, with that is, well, a couple things. One, if the defendant's the one saying it, who cares? It's coming in, it's a party opponent. But the problem with that is then you get a limiting instruction. Do not consider this to whether he was a crip or not. And of course, what's the jury going to do? We're not supposed to think about whether he was a crip or not. Oh, wait a minute. How do we not think that way?
Right? And then you stand up in your argument and you tell them, how do you know this clerk was in fear? Because this guy right here said, I'm a Southside Crip, give me your money or I'm going to kill you. Now remember, you can't consider that for the truth of whether he's a gang member or not, but it doesn't matter if he's a gang member. Right? He could be a choir boy, but he said those things because it put this clerk in fear.
Yeah, because he knew that was going to scare the crap out of the clerk.
Right? And then of course,
And it
but if
did.
you do believe he's a crip.
And it did scare the crap out of the clerk. Because remember, she told us she believed that he was a crip, and she was frightened to death.
So it's,
And all of that would be legitimate argument, even if it's just offered for the fact that the words were spoken.
so don't get caught up on that, right? There's going to be times when you need it to be not for the truth because you don't have an exception, another way to get it at. And you got to start thinking, well, what else can I use this for?
Yeah, obviously that makes a huge difference in the analysis. Because if it comes in because the words were spoken, not whether they're true, hey, great. Then we don't have to worry about all of that, an exception to the hearsay rule and all that other stuff. We can literally say, this isn't hearsay, right? It's just being offered to show that force or fear was used.
And you gotta keep in mind, if you can get it in for the truth, and you want them to believe it's true, then get it in that way.
And of
Right.
course, that statement by the defendant would be admitted because it's not hearsay, because it's a statement of the party opponent. So you could either say it's not being offered for the truth, so it's admissible, because it's not barred by the hearsay rule, or it is being offered for the truth, so it would be hearsay if it was said by somebody else, but it's not because it was said by the defendant. And you could point both out, right?
Right.
You know, I don't have any idea what.
No, I get it. I just feel like some of these concepts, to me personally, are just hard to grasp mentally, and I feel like you have to sit and think about this. I have to sit and think about this very hard, so it's gonna waste time.
So in the book, right, there are some problems, and some of them at the very start of the hearsay discussion have to do with, is it even hearsay? Is it being offered for the truth? So like go through those and think, offered for the truth, not, you know.
Yeah.
I still had trouble on how in the Terrence's note, I understood how Terrence, that note got in. But what was that first level between Dave said to Terrence?
That's a statement of Dave, right?
Mhm.
So that is a level of hearsay.
Yes, I'm saying you know how you have to prove that that gets in?
It's real easy. Just look at the declarant, Dave.
Mhm,
Dave said something.
mhm.
Is it being offered for the truth? Well, darn right it is, because we want the jury to believe that what Dave has said is true. But it's not hearsay. How come? Dave's the defendant, and it's being offered by Dave,
Oh, okay.
right? So now that level of hearsay is satisfied. That statement, you get to move down to, and now we got to deal with Terrence's statement. That level of hearsay. And remember, when you're dealing with statements of a party opponent, they can be multiple levels of hearsay after that, and it doesn't matter because the party opponent said it. So if Dave said that somebody else said that somebody else said something, it's all admissible because Dave said it, right? Dave can make an admission or a statement that covers 3 levels of hearsay. My mother said that my cousin said that his dentist said whatever. And it's all of those levels of hearsay don't matter because Dave said it. And why does that not matter? Because what Dave says isn't hearsay. As long as it's being offered by Penn.
Anything else?
Trish,
He's not a ghost.
For, it's either gonna be civil or criminal.
Right.
Right. You wouldn't combine, would there be a chance of a combination exam?
it's possible to write a question where multiple cases arise out of the same factual scenario. The government prosecutes Dave for causing an injury to a little girl, right?
Right.
And Dave's dad sues.
Mhm.
I mean, Karen's dad sues. That's possible. But it'll be real clear in the question about which is which lawsuit, because otherwise it would be like hugely unfair, right?
Yeah, so you have to be told,
Yeah.
this is in the prosecution's
And
case.
if you read in the question that there are 2 cases and one civil and one criminal, the first thing you should be thinking is, I bet that there are issues I'm gonna have to talk about in connection with one and maybe not the other.
I don't know if it was common practice in exam, for exam taking purposes that you did that. I don't know if that was.
I wouldn't say it's common practice, but,
But
when you think about, like, we had that one example where the witness was elderly and was gonna You know, they weren't sure they was gonna make it, so they went into the jail and they deposed that witness in front of the civil defendant. And the old man said, yeah, that's the guy that did this to me. And now he's being criminally prosecuted. And the issue really was, did the defendant's presence at that deposition in jail constitute an opportunity to cross-examine? So, I mean, maybe something like that, where it's more issue specific, but not, you only got an hour to write this,
Yeah.
right? So we can't give you too many cases to analyze there.
It would be unusual to have that kind of question.
Okay. Thank you.
I'm not saying it's not ever gonna happen, but it'll be real clear if you're getting asked about different cases with the same factual background.
Remember, you can't prosecute ghosts, right? They slip out of their cuffs and you can't keep them in jail, right? They just come right out. Okay, if no other questions. Judge Hop loves when you guys send him emails on the eve of midterm. He'll get right back to you.
And just in case I don't get right back to you, copy. Actually, seriously, I'm gonna be I've got a judicial council meeting on Friday, so I probably won't see your email until like Friday afternoon or evening. I will check my email, but mark it of high importance.
All right, okay. That's it. That's all we got.
You're gonna kick ass and take names. Yes, I'm sure.
Dave? And you gonna offer that for the truth?
I'm an expert.
Sure.
Are
Are you really gonna kick ass and take names, or are you figuratively going to?
No, it's just being honest for the effect on the listener.
Right? That's a good one. Yes.
Yeah, I want to fill everybody with confidence so they rip it up. Tear it up. And I didn't even touch my. See you guys.
All right.
You're here Saturday too?
I'm here Saturday. I heard there's donuts, so I'll be here early. Donuts and coffee or test taking. Yeah.
Hey, Austin, you might just want to just do, I always thought trees matter, so there's the exams, not there's the case back.
Yeah.
I heard.
Yeah.
I saw that.
Injury, but clearly not.
I
I would
was
just
just
analyze both, I would just say it's fine,
Or essays.
what's,
Okay, that's
if you're confused about it, she just say, like, something really confused, just analyze it both ways. You know what I mean? So you'll cover yourself.
I'm just worried about wasting time.
I know, but
Because some of these things, like I wanted to just say, so many of these concepts just mind fuck me, that's
Right.
what the
Because
word
you're-
is, because I
you're
don't have a
very
better word.
analytical and you're reading everything, and I'm the same way. So
Yeah,
you read everything into everything, and I think they're just trying to,
see more of like a big picture,
like when they say calmly walked over, that's what they're looking for. It's, you know what I'm saying?
because I was having the
Me
same
too.
trouble though on the one that they said was not a present sense impression. I'm
Me
like,
too.
arguably that is a present
That's what I
sense
thought.
impression.
Right.
You could argue.
Now I
this.
know the difference, but I totally not have known that.
We'll see, like if I read though on the exam and I don't think about it hard enough, I'm gonna
Right.
miss that.
Right, I know.
And I'm gonna say it's a present sense impression and be wrong,
It's not the same,
I
it's
didn't
not
say.
It's
not
not
the
even
same
an
fact
issue.
pattern.
My point is like, I have to think so critically about these,
Yeah.
and there's so many issues that's why I only got halfway through it, after we took the exam on Saturday, I was like, there's no way I could finish one of these, there's no way,
I know, I mean, it's,
but. And also the logical and legal relevance, those take time too.
that take longer than the hearsay.
Yeah. You
I
you
mean-
can copy and paste a rule statement, but you're
You still have to add something to it.
you're analyzing, yeah, exactly, and I don't know, I wish we did examples of proper analysis for that, because I would love to tighten mine up, because my paragraphs are like that, fact, just fact.
I mean, don't ask me, I would email them and say, look, I think the most important thing they think about is, the most important thing they care about is hearsay. I would make that meteor part. I mean, I don't listen to me, I don't know, but that's what I'm
No,
gonna
you're
do.
right, it's just hard
Because-
to, it's hard to do it and not explain yourself thoroughly with the relevant stuff and not be conclusory. You know, like,
Like you said,
evidence is logically relevant if it makes a fact or consequence more or less probable.
Right.
Here,
I know, it's like a whole analysis in itself.
you know, you have to
I
say
would
like
say-
this is being offered and this could make this
I would say
fact or
something-
consequence more or less probable, therefore it's relevant. Right?
And I would just say something like, here the defense is gonna argue blah, 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 but the prosecution will most likely be successful because blah, blah, blah. Cause I know if you start reading like a couple, each, like, defense gets a sentence and the prosecution gets a sentence, it's like, you don't have time. 'Cause each of those statements is different.
For logical relevance analyses, and then for legal relevance analyses, and
Yeah.
I say that in itself would take how long?
Bye guys.
Bye.
Bye, see you tomorrow.
Yes.
Gosh, I